Hello and welcome to another presentation. In this presentation I'm going to address specifically the attachment of earnings, and I'm going to briefly cover the arguments that you could present to your employer prior to them making an attachment of earnings order, and also talk about a process that you can use if you're already in this position and the attachment of earnings order has already been granted. What is an attachment of earnings order? An attachment of earnings order in the UK is a legal mechanism which a creditor can recover a debt from a debtor's wages. This order is issued by a court and instructs the debtor's employer to deduct a specific amount from the debtor's wages and transfer it to the court, which is then forwarded on to the creditor. Now, since we're dealing specifically with council tax, you will take note that it says the creditor. The council is not a creditor. You have no contract with them. You have purchased nothing from them. You have no agreement to perform from them, and therefore they are not the creditor. Simple as that. Key aspects in attachment of earnings order. An AEO can only be issued if the debtor is employed and owes more than £50. It cannot be applied to individuals who are unemployed or self-employed in the armed forces or a merchant seaman. This is why I suggested a long time ago in one of my earlier presentations that you may wish to subcontract with your employer so that you are in fact self-employed. Creditors can apply for an AEO if the debtor is behind on a payment through a county court judgment, CCJ. Keep in mind that when you're dealing with council tax, it is not done through a county court. It is done through a magistrate's court. The application involves completing a Form N337 and providing detailed information about the debt and the debtor. Well, since they are not the creditor, you can't be the debtor. And you have a right to request a copy of this N337 form, to which they will probably not be able to provide it. Remember that the council tax, when it submits the bulk listings, are done in bulk, exactly that, and so there is not one specific case assigned to that case court file number. You may be on a list of 300 other people or possibly more. Now the process, once the AEO has been applied for, the debtor is notified, which will be you, but you're not really the debtor, and must complete and reply on a Form N56, or at least so they'd have you believe, detailing their financial situation and employment status. Well, if you fill out this N56, if you were foolish enough to do so, you're now informing the court of who your employer is, and they will go directly to your employer and try this attachment of earnings paperwork to frighten your employer into complying to giving money over to the court, which will then be given back to the council. So if you fill that out by accident, well, you shortchange yourself, to put it politely. Now the court will make a decision, and given the fact that the court's best interest to generate revenue is to find you guilty, the court will review the information, or more likely rubber stamp it, and decide to issue the AEO. And then if it is issued, the court will send a copy of the order to the debtor, which is you, but you're not the debtor, to the creditor, which is the council, but they're not the creditor, and to the debtor's employer, which will be your employer, which will all be illegal. Deductions. The employer is supposedly then required to start making deductions from the debtor's wages in accordance with the terms specified by the order, which includes the normal deduction rate and the protected earnings rate, which is the minimum amount that the debtor is allowed to retain to sustain themselves and cover their basic living expenses. Now, they would have you believe that the AEO can be used to recover various types of debts, including rent. Well, rent probably resulted in you going to court, and there probably is a judgment, and you are under contract, so that's probably true. Mortgage arrears? Well, possibly. But mortgage cases or mortgage claims are often fraud unless they're done in the private. A private mortgage, then those rules wouldn't apply. Income tax? No. You have no contract and the whole process is illegal because these corporations, which we call countries, are actually funding other countries and supporting acts of war, which goes against the UN Charter, which states that you're not supposed to financially support countries that are engaged in acts of war. The only time the UN is ever to get involved in anything is to support other UN members against being attacked. And I've notified the Armenian government of this a while back, and I don't think they did a whole heck of a lot with it. Under VAT, no, you wouldn't be liable for that either, because VAT, if the company is registered on Companies House and or is a legitimate company, they would have a VAT number attached to the invoice. Therefore, you would not be liable to pay VAT invoice after the fact. And license arrears. No, you don't have a contract with the BBC unless you've applied for it. And if you don't have a contract, why would you be obligated to pay? Credit card debts? No. Most likely your credit card is an unsecured credit card, and it's actually paid when you sign the promissory note. The same thing is true with the mortgage. If you have a public mortgage with a public bank, your signature on a promissory note created the value to the contract. A bank loan is the same thing as a mortgage. They're paid when you sign the promissory note. Student loan could be argued that you paid that with your promissory note, but more than likely you also agreed to under a contract, and so it's a gray area. It may possibly be enforceable. But more importantly is the council tax arrears. No, you have no contract and the whole process is illegal. If you've listened to any of my previous presentations, I outline in small presentation format where the council tax is operating outside its legal authority, and once there's fraud in one thing, it destroys everything that it touches, which is a legal maxim in law, and I have a separate video on legal maxims if you wish to go back and find it. What happens if the defendant loses their job? Well, obviously the AEO becomes ineffective immediately because there's no wages to deduct the payments. However, if the order was issued, the order itself is not canceled. It remains in force and can be reactivated if the defendant notifies the council or the court of their new employment. Now, according to them, notification requirements, if the defendant is required to inform the court about a change in their employment status. If they find a new job, they must provide the court with the details of their new employer. Failure to do so can result in violation of a court order, legal consequences, which may include fines or imprisonment or potentially both. Now, the creditor's actions. If a creditor stops receiving a payment due to the defendant's unemployment, they can request the court obtain a statement of means from the defendant or require the defendant to explain their current financial situation in a court hearing. Now, reactivation. Once the defendant secures new employment, if they've notified the court, then the AEO will be reinstated with the new employer, and the wage deductions will resume in accordance with the terms of the existing or modified court order. What happens if you've had enough? Well, if you're in this position and you're watching this video, I assume that you've had enough. So what I would suggest is you study the material that's presented in my videos previously. I do have another video that comes out, or that will be coming out, that deals with the committal to prison issue. And then just in short and brief, committal to prison is only applicable on criminal offenses, and therefore, since this is a civil matter, that provision doesn't apply. And also, if you're being harassed by bailiffs, which is another presentation, the bailiffs are there to maintain the peace. They have no jurisdiction in a civil matter, and therefore they are actually breaking the law if they aid and abet and assist the private bailiff. Again, that's the subject for another presentation, so I will continue with this attachment of earnings presentation from here. The first thing that we have to realize that all complaints are done in bulk and given a single case number. This is a huge abuse of process. You will also note that your summons and or paperwork that came with it more than likely does not have a case file number that was issued by the court. This is because the courts do not issue the liability orders. They are issued through software and done and released by the local council, which means the local council is now taking on the judicial function of a court, which is invalid and illegal. All summonses that breach the terms that I just outlined are in violation of Regina versus Bradford Justices, and it's an ex parte case, so somebody didn't show up, more than likely, of 1975. A deduction by magistrates whether to the decision by magistrates whether to issue a summons pursuant to the information laid involves an exercise of judicial function and is not merely administrative. That line there tells you that it is a judicial function. Therefore, how is the local council legally allowed to do this? And in fact, they aren't. A summons or a warrant is merely the machinery giving the defendant notice of a proceeding and for getting him to appear before the court. Now, in a normal court procedure, you have civil court procedures because we're dealing with a civil claim, and the party would start an action, and then they would give you disclosure. And then once the disclosure was done, and you do the preliminary going back and forth, called interrogatories, then what happens is your paperwork escalates and the matter is set down for trial. And you would be therefore given a trial date notice, and you would appear in court, and you would have all this disclosure. Now, because you're simply getting a summons, and they would have you believe it's an official document, that would indicate that you're in a criminal system. Just like when you get a summons for driving under a DUI on the side of the road, driving under the influence of alcohol. So which is it? Is it a civil matter or is it a criminal matter? Well, if you contact your court, you'll find out it's a civil matter. Therefore, they have no rights to issue a direct summons without giving you proper disclosure. That is a violation of civil court procedures. If a magistrate authorizes the issue of a summons, well, the magistrate didn't authorize anything. It's done by software. Without having applied his mind to the information, that means the claim against it with all the evidence, then he or she is guilty of dereliction of duty. If any justice clerk's office practice goes beyond a summons being issued without information being laid before a magistrate at all, then this is a very serious incident. Okay? And there is no evidence laid because it's done in bulk. So the whole process is invalid based on this case law dated back to 1975, which predates the 1992 Local Government Finance Act and the enforcement regulations that's associated with it. Now, if we look at the Magistrate Court Rules 1981, it says right here under Section 98, a summons shall be signed by a justice issuing it, or state his name and be authorized by a signature of the clerk of the magistrate's court. Well, given the fact that these summonses are in fact issued by the local council using software, the magistrate court did not sign it, or if they did sign it, since it was issued via software and sent out by the local council, they would be actually falsely misrepresenting themselves, because that is not a court document. Now, all councils print their own liability orders, and sometimes they contain a crest, which is a huge abuse of process because they're impersonating the court. Now, if we look under Sections 78(2) of the Local Government Act, dating back to 1888, it says, provided the transfer of powers and duties enacted by this Act, and then it carries on, member thereof, they're not allowed to exercise exercise jurisdiction under Summary Justice Act, and then more importantly it says, or perform any judicial business or otherwise act as a justice or justice of the peace. So the local government is not allowed to act as a justice or justice of the peace, and therefore they cannot issue their own summonses because the summons has to be signed by the justice. So therein lies the whole case blown to hell. And they're not permitted to do it. So if you're in an appeals process, either through the valuation band or through the high court, this here would substantiate for the reasons for why the case should be thrown out. Now, this is not all of the reasons, and you'd need to go through my other presentations to get the rest of it, but I don't want to give you an 8-hour conversation on one presentation. Given the complaints are listed in bulk, and no substance, by impossibility, no court or council complies with the case law provided. Therefore, the liability orders are void ab initio, which means from the beginning, and they have no legal effect. No council in the country has the power to issue their own order. That would mean they're acting and abetting criminal activity, and they're acting as a justice, and therefore would be in breach of Section 78 of the Local Government Act, 1888. No court, especially the magistrate court, has the authority to grant a judicial authority to a council so as to issue an order. Those should be issued by the local court. And when you go to file your paperwork, you're told to file it with the council. This is because the council hires the court to do their work for them. That creates a conflict of interest, and given the fact that you're not permitted to enter any evidence into the court, is depriving you of due process of the law. On top of that, your court file, when it's submitted to you, does not have a court file number. It's done in bulk, and when you get your paperwork that comes with the summons, you're not permitted to enter any sort of a defense, which is a violation of the Courts Act again. So the whole process is void because it's based on fraud and depriving you of due process of the law. All these arguments need to be put in a well-crafted, well-documented letter and sent to your employer if they've received one of these notice of liability or a attachment of earnings order. It may be beneficial for you to take the time now to draft such a letter and have it, and then if the situation arises, you can simply pull that file or that document and hand it to your employer if you are engaged in a council tax issue. And this will buy you some time to write the letter and compose it without being, basically under the gun, so to speak. Now, if we look at the liability order, the further provisions, it says a single liability order may deal with one person and one such amount. And you can stop and read the rest of this if you wish. But as I've already pointed out, they're done in bulk, so there's not one liability order dealing with one person and one such amount. And if you ask for a copy of the liability order, they will, if you ask for it properly, you will find out that the document they provide you is a list of names and addresses, and most of them, in fact all of them, except yours, are blanked out. Well, that there means they violated this Tax Enforcement Regulation 1992, which therefore invalidates the entire claim. Again, I repeat the Section 3 of the previous slide, and it says right here, is not to be treated as a sum adjudged or be paid by an order of the court. So they're telling you that the court has no authority to issue the order to force you to pay this council tax. That's under Section 3 of the previous slide. I've simply blown it up here to make it easier for you to read. The attachment of earnings order may be issued by the High Court, it says the Family Court, or the County Court. And then finally under Section 3 it says the Magistrate Court may make an attachment of earnings orders to secure, and it's all blanked out except for C. It says payment of any sum required to be paid under regulations under Sections 23 or 24 of the Legal Aid, Sentencing, and Procurement Offenses Act. Okay? Well, you're not part of that act. Now, there is a comma in there, so one may argue that, but they're relying on the Local Government Finance Act, which we've now proven has no legal authority. Now, this attachment of earnings goes on under Section 5. It says any powers conferred by this act to make an attachment of earnings order includes, which is restricted if you recall, a power to make such an order to secure the discharge of liabilities arising before coming into force of this act. So you can use this Attachment of Earnings Act of 1971 to discharge, or basically, to put in simpler terms, to null and void the attachment of earnings order itself. Remember that the word includes is restrictive. We went through that on another presentation that I went and explained some legal words. Now, if you were to do an attachment of earnings order, if the order is reversed, you'll notice here it says HM Courts and Tribunal Services, because this in the upper corner there on the left is from the actual court. So if you see this type of crest or letterhead on any documents, that are received in respect to council tax, you already know that there are actually evidence of fraud, and given the fact that they've mailed it, is actually mail fraud, and they're actually in violation of several sections of the Fraud Act, which I went through previously. But it says you can get this form under HMCTS Forms Finder justice.gov.uk. Now, this attachment of earnings, okay, who can an attachment of earnings order be made against? And it says here, and I'll blow it up on the next screen. Okay, attachment of earnings. What should I do? It says read the leaflet. So if you were going to do an attachment of earnings, the defendant, you have a judgment, the defendant hasn't paid, and so therefore you can do this. Now, if you have an invalid judgment, because of all the reasons I pointed out in this presentation and other ones, then they have no valid judgment, therefore the attachment of earnings does not apply, and if your employer intends to comply with that order, they can be held jointly and separately liable for a conspiracy to commit fraud and for aiding and abetting criminal activity. It says here an attachment of earnings order will only help if the debtor is employed. So if you're unemployed and you don't wish to go through a major fight, and it's accurate, not telling a lie, then you can inform the court that you're unemployed, and you can bring that up at your time of your trial or your hearing, so that they don't put this attachment of earnings order, which will then follow you around if it is granted. And it can only be done if you owe more than £50. Now, who can attachment of earnings order be made against? You can ask for an attachment of earnings order unless the defendant is unemployed or self-employed. Is a firm or limited company, because obviously a company doesn't make wages, or if that individual is in the Army, Navy, Air Force, or a merchant seaman. Now, if you have an issue with somebody in the military or a merchant seaman, Air Force, Army, or Navy, you can attack them by going to the military and having them do a deduction at source. That's not the purpose of this presentation. But up in the first point it says unemployed or self-employed. This is why before I've suggested that people subcontract with their employer and therefore become self-employed. This is a protectionary measure. Now I've included here, just as a simple show basically, this is what an application for an attachment of earnings order would look like. So you have a right to request a copy of the application of earnings order from the local court and or whoever is doing this attachment of earnings, and you'll find out that when it comes to council tax, generally, if not always, this form doesn't exist because they have no right to do an attachment of earnings because you are not the debtor and them the creditor. Remember that you have no property of theirs, and therefore, and you're under no contract, therefore how can they be the creditor? Now, if you do have an issue that has been, an order that's been issued against you on attachment of earnings, you can fill out an N245 form, which can stop or at least alter this attachment of earnings order. Okay? And it says application to vary, which means change, or discharge, which means get rid of, an order for an attachment of earnings. And you can also change it to installments. So you can cease the attachment of earnings order, potentially. You can adjust the amount deducted from your wages due to hardship. You can extend the time granted to settle the debt. In all these cases, those first 3 points, you would have to prove this. Or you can, as the final option, annul the debt entirely. Entirely, which means you can cancel out the debt. Okay? It is critical to submit this 245 form within a month from the date of the attachment of earnings was issued. So even if you notify your employer of the wrongdoing and they go and do it anyway, be prepared that this N245 form must also go to the court, even if your employer has done this attachment of earnings or not. This way, it's already in the court, and they can't go back to your employer. Now, you want to settle this problem with your employer so they don't do the attachment of earnings, even if they get the notice. This is why I suggest taking their time, drafting the order or drafting the letter, the notice, telling them that they're aiding and abetting criminal activity, and outlining the points that I've presented within this and my previous presentations. You will then be notifying the employer that they can be held jointly, which means collectively, or separately liable for any sufferings that you incur due to the hardship caused by your deduction in pay. This should, hopefully, make your employer at least want to listen to you, and if you do your documents and draft them with the evidence presented in this presentation and my others, they will be thinking twice about doing the attachment of earnings order, and they may in fact be thinking twice about paying their council tax. Councils simply don't have the judicial authority to issue orders. That would be breach of Section 78(2) of the Local Government Act 1888, which supersedes the Local Government Finance Act or anything else. You can also lean on the primary legislation under Section 17. Under the Bill of Rights Act of 1701 and the primary legislation, all of which has been covered in a video presentation entitled Primary Legislation, which is on my YouTube channel. You have another avenue here, the Employment Rights Act. Under Section 13, rights to not suffer unauthorized deductions. An employer shall not make deductions from wages of workers employed by him or her unless the deduction is required or authorized to be made by virtue of a statutory provision. And that's what they will use against your employer. But if you can prove to your employer that they have no statutory provision that's lawfully binding, then you can hold your employer liable and or use paperwork and court processes to potentially nullify the order. Or the other alternative is if the worker has previously put in writing their consent to make the deduction. Now, you may have done that for a separate reason, for tax saving purposes or otherwise, but don't get that conflicted or intermixed with this council tax claim, which is a totally separate issue. The attachment earnings order, again, if we read through it, it says the courts have the power to do this attachment of earnings if it's the High Court, the Family Court, or the County Court. And then under Section 3, the Magistrates Court Act, it's all blanked out except for C. It says payment of any sum required to be paid under regulation under Section 23 or 24 of the Legal Aid, and then there's a comma, Sentencing and Punishment Offenses Act, which does not apply to you. Therefore, the Magistrates Court has no authority to do an attachment of earnings order, because that provision doesn't apply to you. But under Section 5, any power conferred by this Act to make an attachment of earnings order includes the power to make such an order to secure the discharge of liabilities arising before coming into force of this Act. So therefore you can use Section 1(5) to discharge or cancel out the obligation. Now, the Local Government Finance Act, if we read through the first three provisions, they apply to the Secretary of State or the Treasury or the Welsh ministers. They do not apply to the local government and their Local Government Finance Act. Therefore, the Local Government Finance Act 1992, at least under Section 113, does not apply to the local council or borough. Council Tax Administration Enforcement Regulation has the statutory that is the protections of the Attachment of Earnings 1971 supersedes those regulations. So because the Attachment of Earnings Act 1971 and the Local Government Act of 1888 superseded, as does the Bill of Rights, this is based on the principle where there's a conflict between two pieces of legislation, first in time, best in law. Also, if you have a precedent court case from many years ago, that is first in time, so it's best in law, and this is where we get the precedent court case provisions, and I've given you a precedent court case within the context of this presentation. If you have any questions or concerns, you can reach me at the email address provided here. And if you find my work useful and beneficial, I would ask that you make a donation via PayPal to the above address in the amount that you're comfortable with. I'm not doing this for pay, but you probably realize that I've done more video presentations on council tax than anyone, and I've done more work towards that end, and it does take a considerable amount of time to research, compile, and then upload these videos to YouTube. I hope that you found this information useful. I will be providing another video in the near future that deals with the committal to prison, which is another unlawful or illegal act, because that only applies in a criminal case. And for any of those that are being harassed by bailiffs, keep in mind that the bailiffs have no jurisdiction, they have no jurisdiction to enter your property, and they have no jurisdiction to take your goods under the warrant of control or warrant of entry. Warrant of entry only applies to criminal proceedings, and the warrant of control only applies to taking back goods which are belonging to the creditor, and your vehicle does not belong to the creditor. You are in possession of that vehicle. You have an equitable claim, and therefore that trumps any other claim, and the council does not own your vehicle. And when the police come there, they are there to maintain the peace. They have no jurisdiction in a civil matter. Sometimes when you get served these documents, they will bring the police to help them enforce their action, when in actual fact the police are only there to maintain the peace, and if they don't, they too can be held liable. I hope you found this information useful, and I look forward to presenting you additional information in the future as time and resources permit. Thank you, and have a great day.